wait a minute. You're talking to me. You're talking to me.
Yeah.
From the very first second, this courtroom erupts into tension. A defendant interrupts the judge pushes back, and what should have been a routine plea discussion instantly becomes a battle of control, tone, and authority. You are witnessing how quickly negotiations can collapse when emotions overtake procedure. The state has made its offer, the defense is stuck in the middle, and the defendant believes he's being treated unfairly. Is this defiance, confusion, or strategy? As voices rise and patience thins, this hearing is about to shift from a simple legal dispute into a far more serious question about the defendant's ability to even stand trial. Stay focused. This case is about to take a dramatic turn.
Mr. Moore? Mr. Moore?
Yeah.
Yes. Let's not shout at people. Let's not raise our voices. Here's the thing. If an attorney is telling you what the state is offering, all you have to do, if you don't want to accept the offer, just say you don't want to accept it, say you want a jury trial, and you'll get a jury trial. But your attorney can't make the state offer you something that you want them to offer you.
It's not what, no. So it's not what they offer. It's what you're lying on and trying to give me. And I know what I did. It was an argument.
Okay, so here's
the argument. It was an argument. It was an
that
argument.
means you need a jury trial. That's what you're saying. You want a jury trial.
It was an argument between me and my relatives.
All right, let me ask you, who's the
You
prosecutor
start
on this
adding
case?
on extra names onto the case. She added extra names on the, wait a minute. You're talking to me. You're talking to me.
Yeah. Are you the prosecutor on the
You're
case?
talking to me. You said John, you just said John Moore,
Are you
right?
planning on dismissing these charges? All right, so it sounds like they're going to want a jury trial. Are you
At this moment, the judge clearly explains how plea bargaining actually works. The defendant cannot demand the deal he wants. He can only accept or reject what the state offers. When the defendant insists this was just an argument, he minimizes the legal gravity of his situation. The judge remains calm but firm, reminding him that rejecting the offer means requesting a jury trial. This is a critical legal fork in the road. What you're seeing is not personal drama. It is criminal procedure in real time. The defendant's frustration signals a deeper problem. He does not fully grasp how the system operates, and that misunderstanding will soon become central to the case.
planning on offering something different than you've already offered? All right, so is your client going to accept anything or no?
He has just informed me, we talked last night, but he informed me this morning because of some of the particulars, he's not going to accept the agreement.
All right, so nothing will, it sounds as though you all are at an impasse. The state, you're saying that you're not going to offer anything differently. And defense, I'm assuming there's no counter offer, right?
No, at this, I did. I made a counter offer to the state and they rejected it.
All right, so do you have all of the discovery?
I do have all the discovery. If I could, the one thing with moving forward, and it started last night with these outbursts, I'm starting to have potentially some competency issues. I want to stop and pause before I make that decision, but I think I'll need to file a suggestion or motion that he needs to be evaluated for, I really can't communicate with him right now, Judge. And that's part of what I have to do to make sure he's competent.
All right, so is the communication issue, and I don't want to interfere with attorney-client privilege, but is the communication more of he's not accepting your advice or you don't believe he understands?
Sometimes I don't believe he truly
If I didn't
understands.
understand, I would not respond.
Okay,
For one, don't insult me. If
All
I
right.
did not understand,
all right, he can
don't
be
insult me,
excused.
though.
Thank you.
Don't insult me.
All right,
This is the turning point of the entire hearing. The defense attorney is no longer debating evidence. She is questioning whether her client is competent to proceed. When counsel says she cannot effectively communicate with him, the court must take that seriously. Competency is not about guilt or innocence. It is about whether a person understands the charges and can assist in their defense. Notice how carefully the judge navigates attorney-client privilege while still probing the issue. Meanwhile, the defendant grows more agitated, claiming he is being insulted and ganged up on. His reactions only deepen the court's concern that this case cannot move forward without a mental evaluation.
can we set this for a jury trial?
You're ganging up
What
on
day?
me. I'm going, but don't insult me, sir. So if I do not understand the case, I would not respond. You understand that?
Yeah.
Today is.
So let me just tell you, today is Monday. If anybody thought today was not Monday, let me just tell you, today is Monday. Yes.
And I just started seeing this last night.
Okay.
And I understand, I don't know when the court's gonna reset me. I would have to file a motion at this stage on the competency issue, Your Honor.
I would have no objection to that because I've had those concerns myself since I reviewed this case.
All
Well,
right.
and it's, for me, I hadn't seen it yet, but I saw it last night for the first time.
Yes.
All right. Ms. Ferguson, they're going to file a motion to have him evaluated for competency. And I will say this is the first time I've seen him be this way since he's come to court. So,
Same with me.
all right. So what we'll do, Norma, if you can set this for the second week in December, and that's to make sure that everything has been filed.
I can do December 11th.
I will follow it this afternoon, and the second week of December is perfect for me. I live to snow ski and I'm gonna open it this year, the first week of December.
Okay.
So thank you, Your Honor, for that.
You're welcome.
In the end, this hearing was never about sentencing. It was about safeguarding due process. What began as a plea discussion transformed into a formal pause while the court considers a competency evaluation. The judge balanced authority with restraint. The defense protected constitutional rights, and the state stood firm of its offer. This case illustrates that justice is not just about punishment. It is about ensuring a defendant is mentally capable of participating in his own trial. The system may be slow, but it is deliberately designed to prevent injustice. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.